Welcome everybody to the Trustees Training for 2025, our second meeting that we have every year for our life plan clients. And I appreciate you guys still coming out. I'm glad it was warm-ish, and that hopefully we can get you home before the weather comes. So again, thank you for coming. And what we will do to start with is we will go through the packets of information that you have. So as always, there's a business card in there. So if you come to a lot of these meetings, you probably accumulated a lot of business cards, but that's good. You can hand it out to your kids, your financial advisors, whoever. On the left side, there's always that biography of me. So a lot of you that have been coming to these meetings, you're going to know what's on here and have a lot of this information already, but we still have it available as we get new clients that come every year and new trustees and children that come to this every year. So then they can learn a little bit more about me and have the information. So for those of you who don't know me, Cassandra Lusfield, I took over the office in 2023 from Hannon, where I'm continuing to do the estate planning and elder law. And I'm originally from Elkton, South Dakota. I'm not from Wyndham. And then my family and I live outside of Mountain Lake. I graduated from USD Law School in 2016, so I know I look young, but I've been practicing law for like 8 years now. Another thing is I'm a member of the National Academy of Elder Law Attorneys. Then you're going to see the packet of information here, the slide that we're going to go through today. And as always, we printed it out so that way you can take notes as you go. If on the slides the wording is too small, you can't really see what's on there in your printout, just let me know if I need to stay on a slide a little bit longer. Or, you can ask questions, have me repeat things or say it in a different way, just let me know. Can everyone see the screen okay? Those in the back, can you see it good? Perfect. I just wanted to make sure we didn't have to adjust lights or anything, and then everyone can hear me okay? Okay. Then on the right side, we always have a cartoon. I can't remember if we did the same cartoon last year, but I thought this was a good one. So we try to lighten it up where we can when we're talking about death, probate, nursing home, taxes, that kind of thing. So we try to give you a laugh where we can. Then you're going to see that purple sheet is the client suggestion form, client evaluation form. So this is where you can rate your service with our office and leave us some suggestions about what we're doing well, what we can improve on, maybe new things we could do, things like that. And then on the back, you could put, if you want to leave like a client testimonial to put on our website, there's a spot for that. And then for those of you who aren't clients, right, children or other trustees, we're offering on the back and the bottom, there's a free estate plan consultation for new clients. So you can check that box if you'd like to have a free initial consult with me to talk about starting estate planning. Maybe you already have estate planning in place, and so then you can check the review box. When I say estate planning in place, estate planning with a different curve. And so we could review that and see if there needs to be any upgrades or things redone. Or you can just say, no, I'm not interested, or not fill out that code sheet. But we wanted to offer that for any children trustees that are here who are not current clients. And then we have the trustees manual. So of course, we're going to be going over a lot of it today, condensing it and summarizing it with the presentation today. But this manual can be some good light reading, right, for your trustees and your kids if they really want to kind of read through and get a better understanding about what their duties are and roles as a trustee. So if anyone needs any extra copies of that, you can always let us know. And then we could mail one, or you can pick one up at the office if you need. more copies for more of your trustees or children. Okay, so we will get started. So like I said, this meeting is for your trustees, for your kids or your family members, the people you've chosen to be as trustees on your trust. So this is just going to be a general overview of what they can expect as trustees as far as what their roles, duties, and obligations and things are. And this is just intended for general education. It's not providing legal advice or anything like that. And obviously, you should consult legal counsel to determine how the laws will apply to specific situations. So, after this, you can come up and talk to me more privately and ask questions too, where I can give you maybe some more legal advice privately, one-on-one, specific to your situation. Or while the clients who are in life plan, those of you that are here, you have those phone calls, phone calls with me relating to your estate plan questions that is no additional charge. So with that can include your kids calling, your trustees calling. They can also call me. Obviously, you have to give me consent to talk to them first, but they can call me, and if there's questions relating to your specific estate planning, that's going to be covered under your life plan at no additional charge. So you're welcome to call the office and schedule appointments too, as trustees and the kids have questions. Also, we are going to go through the book today, a quick overview of what's in the book for the trustees to see what's in there. But also, I always recommend too for you parents, the people making these trusts, to maybe just sit down and go through it with your trustees, and you can maybe point out some more specific things to your estate planning goals, and sit down with them and look through it. Some people will schedule like a in-person review with me to invite their kids, their trustees, where then I'm doing a personal review of that trust for everybody. So that is what would be charged hourly still in life plan. In office appointments with me are still charged hourly. But some people, they're like, I would rather you explain it to my kids and have all of us around, all of us together. So then, they're like, you usually can explain it better than us. So, and then everyone's there to ask questions, and I'm there to answer at the same time to get everyone all on the same page. So that's always an option as well. Or conference calls. A lot of your trustees might they might live in another state or further away. So we can always set up conference calls. We can set up video chat meetings as well. Okay, so I kind of talked about the attorney-client privilege already, where that prevents me from sharing your private information with other people unless you've given me consent. So on the retainer that you signed when you first hired our office, whether it was Hannon or me to do your estate planning, you did authorize us to talk to like financial advisors, accountants, bankers, sending deeds off to the county recorder, things like that. So that kind of stuff has been authorized with the signed retainer. So that way we can work to help get your assets funded with those certain professionals. So what you have to give me consent on going for is like to talk to your trustees, your kids, or any other people that may not be listed on that retainer, because I can't talk to them without your consent. Okay. So this ends up kind of being like a workshop that I do too in the local communities. I go around and do workshops about estate planning. So that's kind of how we set this up too, to give the trustees and maybe even the parents that just need a refresher on how estate plans work, and why we have you guys set up with revocable living trusts, and why they're the new and better way to do estate planning. So that's kind of what we're going to talk about here, is why most estate plans don't work, and why the trusts are the better way to go these days. Okay, so there's this 3-step strategy to have a good estate plan that is going to work. So you want to work with a counseling-oriented attorney. So that's what I consider myself, and especially since I just specialize in estate planning and elder law, I'm not doing family law or criminal law. So I'm able to really specialize in on estate planning and elder law, which means like medical assistance planning, protecting your assets from the nursing home. So I'm really able to just focus on that, go to trainings just on that. So, your general practice attorneys, they're doing other areas of law and they don't have time just to go to trainings, all the special extra trainings for estate planning and other law. So that's what kind of sets me aside where I'm looking at more, let's get some estate plan documents that are going to help you in the future with any medical assistance, nursing home, that kind of thing. And you want to establish and maintain a professional updating program. So just creating a trust and getting your assets in it, that's not all you have to do, right? So you have to make sure you have some sort of updating program like this life plan program that you're in, where you're making sure that as the years go on, when your family dynamics change, where your assets change, you want to make sure you're keeping this updated, right? It's not just going to automatically do it. So that's what this life plan is for you to be able to keep it updated as life changes at no additional charge. So that life plan gives you changes to your documents at no additional charge. It gives you changes to your asset list. So you have an asset list in the book, and I'll kind of go through this, and some clients might not have it in the trust assets tab, but somewhere you want to show your trustees where this asset list is that we've given you that gives the breakdown of all the assets that you have and whether they're in the trust or not. So that asset list too is something that you can get updated or get assets in and out of your trust that will help you with at no additional charge. So with being in life plan, your life plan packets, your annual client meeting packets, we put your asset list in there. So that's kind of our nudge to you every year to update your assets. So, your bank accounts and things, they change all the time. You don't have to let us know each time those things change. So basically you can just wait to update things every year when we give you your asset list in November at the annual client meeting. Then you can just get that back to us and update it yearly. When you want to update maybe more than yearly is if you have any significant changes to your assets. If you've bought new real estate and maybe it's not in the trust yet, right? Maybe it's not owned by the trust. It wasn't set up, transfer on death to the trust. That's something that you probably want to contact us right away rather than waiting until the yearly review at the end of the year. Just because in case something happens to you, we don't want to worry about any real estate in your individual name. Because in Minnesota, if you have real estate in your individual name on death, it's going to trigger probate. So those kind of significant things we want to keep up on, that you'll have to kind of your obligation as life plan clients is keeping us updated too on how your assets change, how we can help you get those kind of things transferred to the trust. So those trust ID cards that you have in the front of the trust, those can help you. Those have your trust names on it. So they're in the front of the book in the little slot there. There's trust ID cards. That's going to have the trust ID or the trust names for each, like husband and wife's trust, or if it's just a single trust. So trustees and kids that are here today, that's a nice little card that has the actual trust name on it. So then that way, as your parents or whoever, however you're related to them or not, that's how you can, as you get new assets, that's how they can make sure that they're getting it in the trust, that how they can do it themselves. Maybe the day they go to the bank, they need to set up a new bank account and they want it payable on death like the rest of their bank accounts or owned by the trust right now. Bring that card in and tell the bank, okay, here's the name that I need this owned by or that I need the beneficiary to. So that card is helpful for the clients to be able to help keep assets transferred to their trust and to help kind of do it themselves right away when they acquire that asset. That name is how we prefer assets to be titled to, but it can be shortened. The trusts allow it to be shortened as long as we know whose trust it is, the name, and that it's a trust. So also with Life Plan, we're helping you do those changes as your life and assets change. We're also, besides just like those personal changes, there might be law changes, non-tax law, tax law changes. We're keeping you updated on that. So that's something to make a good estate plan and to make it work, is you want to make sure that your plan over the years is staying up to date with any law changes and things like that as well. And then also with Life Plan, like I said, I'm going to specific estate planning, elder law trainings throughout the year where I'm trying to make myself better so then that way I can make your trust better. So my goal is hopefully that every couple of years that I'm doing trust, I'm making them better for clients. And then with the Life Plan clients, then I tell you, hey, here's ways you can improve your trust, or paragraphs that you could add to your trust to make it better from things I learned at my training. So those are things you can do to update your planning as well, if it's not like personal changes or anything like that. So those are the main things that you want to do to make sure your plan is still going to work. Because just because you have this trust, you have your assets in it, we got to make sure that it's being updated with any changes, assets are being put in the trust as you continue to get assets, so it's still going to work the way we want it to. And then by doing a trust, by doing a good estate plan that works, the point of doing the trust is trying to make sure that also on like disability and death, it's going to be smoother and easier to administer and hopefully have less in costs. And the goal is to avoid probate, right? Where probate is the process, for those of you who may not know, where you have to go through the court to get your assets distributed out, get your executors or personal representatives of your will in charge of those assets. So it's something almost everyone wants to try to avoid because it's expensive, it's public, and it can take a long time. So we're trying to prevent those things by having a trust in place. So traditional planning, so I guess I kind of got ahead of myself here, but so we talked about probate. A couple other things about probate is that it's can be a hassle for your clients, your kids, your people who are in charge, right? Because they have to wait for the court to issue documents before they have access to your assets usually. And there has to be publication in the paper for 2 weeks before a hearing and things like that. So there's a lot of things that can help to delay it, right? We got to wait for the court to submit a document before we can move on to the next step. So by having your assets in the trust on death, that is going to help avoid probate. So some of you might have your assets owned by the trust right now. And that's okay. That's usually how we prefer it. And that's how Hannon did it over the years, was transferring assets directly to the trust. But over the years, we noticed some hassles for clients, right? If we were changing ownership of like bank accounts, you would need to get new bank account numbers, new checkbooks. It would mess up your auto withdrawal, auto deposit, stuff like that. So over the years, we've been doing a lot of payable on death to the trust. So some of you here might have done your plans a long time ago where all your assets are owned by the trust now, and that's good. But also a lot of you might have payable on death to the trust, which is still good too, because no matter what, in either option on death, we have your assets in the trust to avoid probate. So the traditional planning was with wills. And so with wills, the downsides to that is that on death, it's just going to go to your beneficiaries in their individual names, or everything is just going to go to spouse on death. Well, as some of you may have learned, that sometimes that can be a problem with protecting assets on death from divorcing spouses, creditors, and things. Once your kids get it, it could have estate tax planning issues, right? Because if we have just everything going over to spouse, and maybe you use that unlimited marital deduction on first death to say, okay, there's no taxes on my death, everything goes to spouse. Well, then they have the whole estate in their name, and then spouse might be in a taxable estate. So in Minnesota, right now it's $3 million when you pass away for estate tax, and it's going to stay the same next year. So that's what we're looking at, is if you're over that $3 million on each death, there would be estate tax due. So that's where those revocable living trusts come in. So our clients each have a separate revocable living trust for like husband and wife. So what we try to do is we try to put about half of their total assets in each trust. So then that way, when one passes away, we're only counting the half that was in their trust or what's in their name. And we're hoping we balanced it out good enough to where we're making sure on first death we're below that $3 million to have zero estate taxes. And then when the second one passes, we're just counting what's in their trust. We don't count what is in the first spouse's trust. So there again, we're trying to make sure we're only counting half of the estate, trying to make sure we're under that $3 million. So with these revocable living trust plans, you could get up to $6 million as a married couple with zero estate taxes. And even you just got to make sure how it's balanced, right? If you didn't have a trust. But that trust can help ensure, and we're helping you get those assets, and we're balancing it out for you to make sure that we're either below that $3 million, or depending on your assets, we can't always make that work, right? Where it's going to help you try to be at least by counting half of it, we're trying to be as minimal above the $3 million that we can, and try to reduce some estate taxes for you. So then with wills, where, okay, so it goes to spouse, we talked about the downsides of estate tax planning. Another thing there is like bloodline protection. So first death. So you pass away, maybe your spouse remarries. There's not any in a will necessarily that protection, right? Where, so on death, all your assets go to your spouse. Well, they remarry. Unless they get a prenup and things set up on their own, you might risk some of your assets going to a new spouse and their kids with the will. So with our revocable living trusts, on first death, we have this bloodline protection built in, where on first death, if the other spouse remarries, our trusts say that, hey, you have to get a prenup done with your new spouse within 30 days. So it's going to require it to make them do it, or they're going to lose access to the share of the assets that you had in your estate when you passed away. So the trust is going to come with that more bloodline protection. And then on second death, there's more bloodline protection that kicks in too. So in a will, okay, it goes to your spouse, and then when spouse dies, it just goes to your kids. Well, it's in a will, it's just going to go to your kids, your beneficiaries, in their individual names. So then it's theirs. They can do what they want with it. It's up for grabs for divorcing spouses, creditors, and it's going to pass down on their death according to their personal estate plan. Right, so it might go to spouse first before your grandchildren. So with the revocable living trust that all of you have in this room, it is protecting rather than it just going into the individual names for your beneficiaries. We have it set up that on death, it's going to your beneficiaries in a trust, where it's not going to be owned in their individual name, but it's going to be their name lifetime trust is what we call it. So most of you have it set up that your kids can still have full access to it. They can still take out, they can still use their inheritance as they need, But when the assets stay owned in the name of this lifetime trust, it protects their inheritance from divorcing spouses, creditors. And then in the parents' revocable living trust, they have already said, okay, well, when my kids pass away on death, whatever's left in their trust, I want it to go to their kids. And if they don't have any kids, I want it to go back up to my kids and things to stay in the bloodlines. Okay. Sorry, I thought there was a question. So those are a lot of the main differences between having a will and a trust. So the trusts are helping more with that tax planning, the bloodline protection, and just having a more detailed and instructional plan for incapacity and death. Also, with wills, what a lot of people don't know is that they think, oh, I have a will. It's just going to go to my kids. It says it's going to my kids on death. It's fine. That's all I need because that's what I want. Well, it depends how that asset is owned on death, right? So your will might have to go through probate if the assets you have on death are owned in your individual name when it's real estate of any value or other assets that total to over 75,000. So even if you have that will might have to go through probate to give those assets to your spouse or to your kids. So it's very important how you own your assets on death, right? And that's why we make sure that all your assets on death are going to be owned by your trust. So for those of you, the kids or other people here, trustees, those of you who may not have a trust in place, what you want to do is you want to make sure you have at least that you have beneficiaries on everything, right? That bank accounts, investments, retirement, non-retirement investments, life insurance, real estate, making sure that you have a beneficiary on all those. So like real estate would be a transfer on death deed that says on my death or when me and my spouse go on death, it goes to my kids. So at least you'd have that, right? That can help avoid probate when you have a beneficiary set up on everything. And then that's what's going to help your will not go through probate. But obviously the downside to that with just beneficiary designations to your kids specifically is then again, it's in their individual names. They can do whatever they want with it. You don't have that divorce and creditor protection, that bloodline protection. So that's where we like to take it that step further, where you establish a revocable living trust, and then everything, all your assets are beneficiary to the trust. So revocable living trusts with no updating, no planning. We talked about how those probably aren't going to work, right? If you are not making sure that your assets are transferred to it, when you first set them up, we at least help you get your assets transferred to it right away. But as you get new assets, if they're not in the trust, it could trigger probate for that asset, right? Or if you just have beneficiaries set up on some accounts, at least it's going to help with probate, but it's not your trust. It won't go down protected to your kids, your beneficiaries, like the rest of the assets that you have in your trust. So just having this trust and no updating isn't necessarily going to work out the way you want it to, especially if your assets, your personal life has changed. Maybe you had trustees in charge that's not going to work out anymore. Whether they, don't get along with them anymore, or what a lot of people will do is if they set up their trust when they're younger and they have other family members as the trustees and not their kids, right? So as your kids get older and over 18, maybe you want them as trustees. So making sure that you're updating that and changing that, because all of a sudden you're older, you pass away, and your kids are the ones who are involved with you and your assets, but it says, oh, your brother that you haven't talked to in 10 years is in charge of your trust, So those kind of things you want to make sure you keep updated with the trust. So what is a trust? These revocable living trusts are trusts that the people who make them, the clients here, you can change them. You can redo them amend them. You can even revoke them if you want when you're alive and well. These revocable living trusts are trusts that the trust makers have full access and control to and of the assets that are in it when they're alive and well. So, and how we set it up, those who have beneficiary to the trust, well, nothing's really going to change. The assets are going to stay in your individual name while you're alive. So you still have the same access and control to it. And then on death, it's going to the trust. But even if it's owned by your revocable living trust now, we make sure that the trustees of the trust right now are, if it's a married couple setting it up, that it's the spouses, that they're both trustees of each other's trusts, so that no matter what asset is in which trust, because we're splitting it half and half, that both spouses still have the access and control to those assets. So it's like a bucket. When I'm saying that we need to actually transfer your assets, we call it funding, where we need to actually transfer your assets and get it into the trust for it to work. So trust is like a bucket where we need to put your assets into it to protect it from probate, to protect it from divorcing spouses and keep that bloodline protection. So the assets that we're wanting to put in it. So like I said, we're trying to put most of all the assets that you have, anything that has a title, a deed, document to show ownership. So we're making sure that all bank accounts are owned by your trust now, or there is a beneficiary on death to the trust, because we have to have those beneficiaries set up before you pass away. So we're doing all that with your current assets. When you first come to us to do a plan, we do that with all your current assets you have at the time. And then obviously as you get new assets, you set it up yourself or you have us help you get those new assets into the bucket. So investments, so non-retirement investments. Those we typically are probably going to have beneficiary to the trust. If it's a retirement account, we'll keep those beneficiary to the spouse first. There's a spouse for the spousal benefits, and then we'll do second beneficiary to the trust. So this is where sometimes it gets confusing too with your financial advisors and things, because they're like, well, no, you want it to go to your kids. So after your spouse, you need to put your kids on as beneficiaries in their individual names. Well, yes, we want it to go to the kids, but they don't know that in our trust, we are having the trust as the second beneficiary. So it's still going to your kids the same way, but it's going protected, right? Because when you have it go to your kids through your trust as the beneficiary, it goes to them with that divorce and creditor protection. Rather, if you just had them on your retirement accounts in their individual names, then you don't have those protections. So that's how we do investments. First spouse, secondary trust. Then life insurance. We're typically doing that beneficiary to the trust. So whoever's life insurance it is, it'll go on death to their trust. That's how we try to balance it out. So when you're looking at your asset list or kids trustees are looking at their asset lists, how we put like real estate into the bucket is we do that half and half, because that's usually where the significant chunk of value is for their estate. So we're saying that half of, whether it's now or on death, half of the interest in the real estate is going to husband's trust, half of the interest in the real estate going to wife's trust to help split that value up on each death. So that is an asset that's going to be owned by both trusts, is the real estate. But the rest of it, Allison here, our funding coordinator, she'll look at, okay, she'll divide the real estate half and half, and then she'll go and look at, okay, what's just in husband's name, just in wife's name, and then she'll have those going on death to that person's trust. And then she'll go back and look, okay, well, joint assets. Then she'll kind of just fill that in and balance it out in someone's trust, because maybe one's heavier than the other, so maybe some other joint assets are just going to go in wife's, or things like that. So that kind of helps explain to you when you look at those asset lists and it shows you whose trust it's owned by or whose trust it's going in. Sometimes you look at all bank accounts and it's payable on death to just one spouse, but that's just kind of how it balanced out. But because the spouses are trustees of each other's trusts, it's okay that it's just in one spouse's trust because they're still going to have that access and control while they're alive. And then when that spouse passes away, and then all of a sudden your bank accounts are in your deceased spouse's trust. And again, that's okay because we have your trust set up that the surviving spouse is going to be a trustee of that deceased spouse's trust, typically with one of the kids as co-trustees. So then the spouse is still going to have access and control on death to the first spouse's assets. Because remember, we don't want it just going all over to them in your spouse's name. That can create some estate tax issues, bloodline protection issues, right? So we're having the first half go down into what's called that family trust, where the surviving spouse is going to still be a trustee. There's still going to be, most of you have it set up that the surviving spouse is going to be the beneficiary of that trust, the only beneficiary that has access to the assets in there. So we have it set up, though, that even on death, the surviving spouse is still going to have access and control as long as they're alive and well. Let's see. Vehicles. So a lot of you asked me how we deal with vehicles, and on a lot of your asset lists, you're probably going to see client to transfer, right? So we can't actually transfer your vehicles for you or go get a new title for you. You have to help initiate that. So what a lot of you probably had is when you did your funding meeting, when you first set your trust up with us, we gave you instructions. Okay, here's the name of your vehicle on the top, and here's whose trust we recommend you to do a transfer title in. But during that meeting, I'm often talking to clients like, okay, you don't have to transfer every titled vehicle or trailer or whatever you have. Some of you have a lot of them. You don't necessarily have to transfer all of them. So we're kind of playing that game of, well, what are they valued at? Is everything just titled in husband's name or sons and wives and joint? So we're kind of trying to look at that value. If we don't put the vehicles in trust on that, whose name is it in and what's the total going to be? We're trying to make sure it doesn't total to more than $75,000 because we're making sure all your other assets are in the trust. So that hopefully we can just look at vehicles and total those up and make sure those are below 75,000. So it's oftentimes for your main personal vehicles or semis, things like that, that are going to have a high value, especially if you have a nice personal vehicle. I'll typically recommend, hey, you might want to transfer those to the trust, right? So then those higher chunk values are out of the equation, and we're maybe just dealing with these couple thousand a piece, trailers or junker vehicles and things that aren't going to total to over 75,000. So then you don't have to do a transfer title for everything and pay a transfer fee for each one. A newer thing we've been doing with vehicles is you can designate a beneficiary on death for your vehicles. So those of you who have created a trust recently, we have probably given you an application where you can set your vehicle up on death to the trust. So that's something that is probably a better way to go about it rather than just transferring it to your trust now, because trying to trade or sell out of a trust can be a little harder, and dealerships and things are just, they're not sure how to do it. Like, you can do it and you just have to provide an extra document, right? But they're not really quite sure how to handle it. So it probably is better, as we've learned over the last couple of years, maybe just set those vehicles up that we need to have in the trust on death, setting them up beneficiary to the trust. So if you are interested in doing that with some vehicles rather than transferring titles, you can always call us, let us know. Allison can email you that application. So what she'll do is she can fill it out as much as she can if she knows your information, who's on the title, what the vehicle is. Excuse me. But you have to fill in like your driver's license number, the VIN, and things like that. So oftentimes we'll give it to you and she'll flag it to say, okay, here's where you need to fill this in. Here's where you need to date and sign it. And then you would take it to the DMV or wherever to get that beneficiary designation. Since this is something so new that we've been doing, I haven't had a lot of feedback from clients on whether they think you get a new title when you do this beneficiary designation. On the application, it says that you shouldn't get a new title, but I don't know if some places would make you do that. It says you're payable on death right under the owner of the vehicle. So that's still kind of something that we're trying to learn about. If they're going to make you get a new title or pay a new fee to do that beneficiary designation. So if any of you do that, please let us know what kind of feedback you're getting at like the DMV, if they're making you pay for it, if they're making you get a new title. So then that way we can kind of advise people as we go too. So that's a new thing. And so just let us know if you need us to get you a copy of that application. You can also go online and find it as well. Or if you go into your local DMV, they should be able to provide one to you as well. Okay, then a lot of people, we got farmers in here. We have a lot of assets that don't have a document to show ownership, don't have a title. So with those things, that personal property, machinery, tools, equipment, jewelry, guns, gold, silver, coin collections, antiques, collectibles, those kind of things. So we have those covered when the clients first set up their trust. In the very back of their book, there's a personal property tab, and there's going to be an assignment of personal property in there. So that's where they said, all my personal property is in my trust. So that's how we help take care of that. The law allows us just to sign that one paper, have it notarized, and it gets those type of assets into your trust. So then we don't have to worry about, oh, my machinery and things are going to total to more than $75,000. Well, by signing that, it's in the trust. We don't have to worry about probate for those type of things. Let's see, is there any assets I'm missing? I think those are the main ones that you want to make sure as you're accruing new assets like those, you're getting those set up to the trust as owner right away or payable on death to the trust. So we'll get a lot of calls too where people say, okay, we're getting a new vehicle or we're purchasing new land. Whose trust should we have it in? How should we do this? And certainly under life plan, call us because we can help guide you and look at your asset list to see, husbands is kind of heavy right now. You might want to put this real estate. Well, real estate we do half and half, but it might be say, okay, you might want to put this asset in the other trust when we're looking at balancing it. And usually what we tell people is if you're acquiring new real estate or something, you could just put it right in the name of your trust. But if you want to keep it consistent with the rest of your assets, if the rest of your assets are all beneficiary to the trust and you want to keep it consistent, then you could just keep it set up like that, beneficiary to a trust. Or for those of you who have had plans for a while that set them up with Canon that have all your assets owned in the trust now, as you get new assets, then maybe you want to put those owned in your trust right away to be consistent with the rest of your assets. Question?
I'm thinking of machinery, some of that. Should that be listed under our personal property on this page and decide?
Yeah, so the question is if you farm and you have machinery and things, in the personal property tab, there's a personal property memorandum where you can write down, hey, I want these specific things to go to these specific people. So she's wondering, do you have to write machinery and stuff down on there? So the general answer is going to be no, because we're typically trying to put that in your trust document itself with machinery. Usually we're saying machinery, tools, and equipment is going to go to this farming heir on death, or there's a first right to purchase from the siblings to the farming heir, the machinery, tools, and equipment. So I prefer to have that detailed out in like your Article 7 if you're a single person, or Article 10 as a married couple, that machinery. Or we're not mentioning it at all, and then it just goes into the pot for the kids that goes equally. So for machinery and stuff, yes, I'd like to have that more specific within your trust document. That personal property memorandum in the back where you can write where you want things to go to, I would keep that for like jewelry, guns, antiques, collectibles, your household goods, your china, your hutches, things like that. What I think you mainly want to use that for. Okay, so types of trusts. So wills can create trusts on death. Those are called testamentary trusts. And those we don't like because you would have to go through probate to create that trust. So sometimes you see wills that will create all these trusts to protect it and things. Well, you got to go through probate to do it. So it's just easier to set up a revocable living trust that's going to create those trusts for your beneficiaries on death that will avoid probate. So I've already talked about the revocable living trust, and then there is an irrevocable trust. So sometimes this part gets confusing, right? Because you can set up irrevocable trusts while you're alive that can help protect assets from the nursing home, help you with estate tax reduction planning to get assets out of your estate on death. But also, when we look at your revocable living trust, when you pass away, your revocable living trust is going to turn irrevocable. So then that tells your spouse and your beneficiaries, hey, you can't change anything that I set up when I was alive unless I give you any specific direction in my trust that says you can change things. So there's kind of two separate kind of irrevocable trusts there. So anytime someone passes away, any trust created under that is irrevocable. So that family trust I talked about, or when it's going down to the kids in trust, those trusts are irrevocable, can't be changed unless the parents, the trust makers, gave those beneficiaries any powers to change it. But then, like I've been talking about the last couple of years at our annual client meeting, we can do those irrevocable trusts to specifically protect your assets from the nursing home. So the revocable living trusts you have set up, they don't protect your assets from the nursing home just by having your assets titled to those revocable living trusts. But they provide the foundation and some planning to be able to protect it, right? So the revocable living trust, the common law power of attorneys that you guys all have, they're going to allow gifting. And if you can't, it allows your trustees to gift for you. And it allows them to gift whatever asset they may need to, and it gives them unlimited gifting. So that's how revocable living trust and a power of attorney, they're still have nursing home planning kind of built into it, because if you can't gift, it's still allowing your kids to. Because if you have a statutory power of attorney, that's typically going to limit your kid. If your child is in charge of your finances for you under your power of attorney, it's going to limit them to what they can give per year, and it's going to limit them to the federal annual gift exemption, which is $19,000 per year per person. What you can gift before having to file a gift tax return this year, and it's going to stay for next year at $19,000. So that's where our trusts and our common law power of attorneys, it's helping down the road if we need to gift or your kids need to gift out of your name to protect it from the nursing home, it allows them to do it too. But they have to get it out of your name. They have to get it out of your revocable living trust where you have that full access and control to it. Because for it to work, to protect from the nursing home and to get on medical assistance, you can't have any access or control to that asset. So a lot of people confuse it, right? Well, I thought by having it in the trust, it protects it from the nursing home. Well, no, but you have the foundation built in there to where we could later on be able to gift it out. And so what you're doing is you're gifting like to your beneficiaries, to your kids, or to get it out of your name, get it to them early. So, you know, a lot of people kind of get nervous when I say it allows your kids to gift your assets for you. Well, they're having to gift according to your estate plan. They're going to gift to them and their siblings. They're gifting to your kids early to get it out of your name to protect it from the nursing home. So one kid, if you just have one of your children as the acting trustee, they can't just say, well, I like me, I'm having everything go to me, I'm gifting the heck with my siblings. They still have to follow your estate plan if they're gifting early. So that says that too, right in the power of attorneys and things. So that's why we need to have, oh, question.
You would still have to do that 5 years ahead of time or something?
Yeah, so he said you still have to do that 5 years ahead of time. So when you gift, there is a 5-year look back for medical assistance. So to get on medical assistance, the county says that if you have gifted within the previous 5 years, you can't qualify for medical assistance. And if you apply and you have gifted, they're gonna say, nope, you're denied, and they're gonna give you a penalty of X amount of more months that you can't qualify. So yes, there is that 5-year look back after gifting. So you don't want to just gift and you'd be like, oh, it's just easy. I'm just going to gift, or I just want to sign this deed over to my kids. You kind of got to think about that too, right? Well, what if I go into the nursing home within the next 5 years? If I gift these assets out, do I have enough other assets to help pay out of pocket for the next 5 years because I can't get on medical assistance? Even if your assets are dwindled down to where it qualifies you for the asset limits for medical assistance, if you have gifted, you still have to wait out that 5 years after gifting. And so the federal government says, right, you can gift up to $19,000 per year per person, but the county treats it differently. They're going to say, the law says that if you have gifted anything to anybody that you receive less than fair market value to, it's going to trigger that gift in that 5-year look back. So it doesn't matter if it's below the 19,000 for medical assistance. A lot of people have asked me too, they're like, is it changing to 7 years? I think there's a lot of rumors going around about the gifting changing to 7 years. So as of right now, it's just rumors. There's nothing solid or anything about that changing. So it's still that 5-year look back for gifting for medical assistance. And also a lot of people confuse it. They're like, well, so I can't go into the nursing home for 5 years then after a gift. Well, not necessarily, right? You could go into the nursing home, but you just can't get on medical assistance to pay for it. You would have to make sure that you have enough other funds out of pocket to help pay for it until you can get on medical assistance. All right. So that tax planning, the AB trust, that's what I've already been talking about, is on death, first death that goes down into a family trust. So we call it family trust. A lot of times they're calling it AB trust a long time ago, but how we have your plan set up is on death, first death, it's going to create that family trust where you can have up to the lower of the Minnesota and federal estate tax exemption in, which is $3 million right now for Minnesota, into that family trust with zero taxes. And then your trust also have a backup plan built into them for estate tax planning, where it says it could also create a marital trust. So if you pass away, maybe you're at $3,500,000. So you can get up to $3 million in the family trust with zero taxes, and then your trust is automatically going to create a marital trust for the overage, that $500,000. That there's a formula built into your trust that we can avoid tax on that on first death, but it will go to the surviving spouse's estate and affect what's in their estate and might have to be taxed on it on second death. So that's these AB trusts. For you all that are here, it's the family and marital trusts that we're creating for the estate tax planning. So that's going to be in, for married couples, that's going to be Articles 7, 8, and 9 in the married couples trust. I'm not sure. I think it's, let's see. So if you're a single person, it's not going to be in there, right? Because you don't need that estate tax planning, splitting things up half and half in that marital trust. So married couples, it's 7, 8, 9. That's creating that family trust, that marital trust. And then in the family trust, I think that's usually going to be Article 9. That's where it's going to say in the family trust, how it's handled is that my spouse is the only beneficiary. They get access to income and principal. They remarry. There's that prenup in there. And then it's also going to tell them in the family trust if they have any powers to change your trust once you're gone.
So like the trust that we're talking about, 3,500,000. Yes, yeah, that's five spouses. So I'm asking first, only 500,000,
Right.
and then I would keep the, I,
Yeah, so the question is if you are a married couple and in each half of your trust you have 3,500,000. So on first death, right, you get the 3,000,000 zero tax, and then you can defer the tax on the 500,000 till second death. But then you're still looking at the second spouse, so they have that 500,000 plus their 3,500,000, right? So what you look at is they're not taxed on the whole 7 million. It's looking at like whatever they have left in their trust. So, while they're alive, they have some time if they need to reduce their estate, right? They could maybe be doing that. Whether they're using it for themselves or they're gifting or things like that. There's some opportunity to bring them below the 3 million if we want to try to get zero taxes on second death then as well.
and if you can't,
And if you can't, then whatever the surviving spouse has left above the 3 million, then that's what they're taxed on.
not the whole 7.
Right, not the whole 7. Okay, so next I'm going to talk about this trustee word that I've been talking about all morning. So what is a trustee? So a trustee can be an individual person or it can be a licensed professional, a trust company, but most people, and usually I recommend most people to choose individuals, to choose their spouse and their kids, because they're the ones who are involved with the assets. But obviously, maybe if some people don't have any kids or they don't have good options as kids to be a responsible trustee, you can pick like a professional. So sometimes some of you might even have Hannon listed in your documents as backup trustees as a professional, and that's okay. He has said that's okay. He'll continue to be a trustee. So if you ever need him, obviously your estate or your other trustees are paying him hourly to be that. Or some of you have me on there as a backup. So usually we're on as a backup, so then hopefully we aren't having to do it. You can have your main choices that are the trustees, but if need be, that is an option to have us listed as a trustee as well. Or some people will have, there's some financial advisors and accountants in the area who are retired that will provide power of attorney trustee services at like an hourly rate. So usually if you're getting a professional involved, you probably want to go that route rather than like a trust company or a bank, because the trust company or bank, they're probably going to charge you a percentage every year no matter what they're doing. Whereas if you have a professional like an attorney, accountant, financial advisor, they're just charging you hourly. So whenever they do something, then that's when you're charged. So that might be a cheaper option. But most people will be choosing their kids. And so then this trustee owes a special duty of care to the beneficiaries of the trust. they're in a position of trust, service, and loyalty. So they obviously have to follow the rules in your trust, and they could be held liable if they don't follow those rules. And so obviously they can't just take your money and use it for themselves, right? Depending who's the beneficiary at that time, maybe it's you on mental incapacity, they can only use your money for you, to financially support you, unless it says in your trust, you can distribute out on my mental incapacity to these people, you know. So you've got to pay attention to any specifics in the trust. So they have to follow that. And, you know, same on death. They have to follow your instructions on who they're distributing to. So successor trustee. So successor trustee is a trustee who takes over after the current acting trustee. So in all of your trusts, it's either going to be in Article 2, mainly it's going to be in Article 3, that's talking about trustees, where we're setting up the trustees on your mental incapacity and death. And so what we like to have at least 3 backup successor trustees. So then that way, while you're alive and well, you were able to choose who your backups are going to be if your first choice can't do it. So then you have that power and control to make sure, okay, well, here's the people that I think would be good at it, that I want to be doing it. So oftentimes in your Article 3, you're going to see like on death or on incapacity and death, if your spouse is still alive, it's going to be spouse and one of your kids typically. So for those kids who are here, I'll tell you that I tell clients I recommend them to only pick one child to be a co-trustee with the spouse. Just because when you start to get, like if you want all the kids on there with the spouse, that's more people you have to involve, more people you have to get together to try to make decisions together and all agree. You've got more opinions rolling around. So it just makes things a little harder. So I'm recommending to your parents, I say, try to just pick one, you know, that you think that would be the best at it. And a lot of people are like, well, I don't know who to choose, you know, I don't want to pick or show favorites or anything. And I say, well, blame it on me, right? Like, I want you to pick the child who would be the best at it, be willing to do it, things like that. Some people will use like, okay, these people live closer to me. You know, they'd be able to do this things better. You know, usually there's always a child that is just better with finances and things, right? So you want to pick that person. You want to pick someone that's going to be responsible and good at it, and then we put your other kids as backups then. So for those kids here, I tell clients that you only want 2 trustees at a time, and you don't necessarily want to go oldest to youngest or have everyone in charge together. Question?
Is there anything in here about compensation before service goes?
So the question was, is there anything in the documents about compensation for those who serve as trustees? So yes, in your trust, and I can't remember which article it is, but in the back of your trust with like all the trust administration rules, there is a paragraph in there that says trustees, and it's under Minnesota law that says trustees can be allowed to compensation if they ask for it. But it just says a reasonable amount. It doesn't give you like a guideline of here's a certain percentage of the estate they should get, you know. So it says a reasonable amount. So if I'm helping with the administration of the trust on death, helping your spouse, helping your kids, I let them know that. And so like as we're looking at all the expenses of a trust, I say, okay, come up with a reasonable amount, whether you're looking at your mileage, according to, you know, what you can get if you're, you know, running a business and getting yourself mileage back. I think it's like 70 cents or something now, something like that per mile. So whether you want your mileage back, or if you kind of want to set like an hourly rate, you know, usually I say probably, you know, if you want to do like 50 an hour, usually that's reasonable. You know, if you're doing all the maybe healthcare, finances, all those things. So I tell them kind of throw out a reasonable number, what you think, and then we bring it to all the beneficiaries. And if all the beneficiaries agree, and if all the beneficiaries are like, I don't need a breakdown of all your outs, then we can be good and move forward, and it's an expense that you get paid. Otherwise, if the beneficiaries are like, no, I want a separate accounting, separate breakdown of everything you've done, where where you travel to in your miles, then we might have to do that if you really want to get reimbursed for it. But yes, that is something that they can ask for, is compensation to be reimbursed for what they do. Most of the times your kids aren't gonna ask for it, right? Sometimes people will have it specifically written in there, though, into their trust. If they know that, hey, my trustee's not gonna ask for it, or hey, my trustees are my friends, or someone else besides my kids that I'm having take on this duty. They're like, I wanna make sure they get reimbursed, or they get paid for their services. So a lot of times people will specifically put that on death, and they say, on death, this trustee gets this X amount of money, or usually I say it's better to do a percentage of your total estate, just because you don't know what's going to be left on death, and so then you can say this percentage, 1% or whatever you want to do, is going to go to the trustee. Let's see, I've already talked about a lot of that. And the trustees have a duty to the beneficiaries. They have to account to the beneficiaries. Just like trustee compensation. The beneficiaries can request this final accounting and want, hey, I want statements from all the assets that mom and dad had on date of death, and I want to know the income coming in after death, and I want to know the expenses, and seeing all the statements. Like they technically can request that. The trustee has that duty to provide it to them, and being fully transparent with them. So that's something that we don't see a whole lot happen in our trust administrations, but sometimes it does, right? Sometimes, even if we have everything set up really good to try to prevent those family fights, sometimes there's still a child who might just cause problems because they want to cause problems, right? They want to request those things. And unfortunately, the trustees would have to do it. So, sometimes I get people who are like, oh, we had a trust. This was supposed to be easy. And all these things, or a spouse, they're like, oh, this is so stressful. It's supposed to be easy. And I just want you all to know that, it's going to be easier than going through probate things and having it public. But it kind of depends on the kids and the companies you're dealing with. They might make it a little harder than it should be. And we just kind of have to play the game and get them what we're required to get them. But sometimes there still might be some hassles and extra stressors along the way. But there's still going to be to-dos on death. Just having a trust is not just, it's automatic, everything's going to flow easily. There's still going to be some to-dos and some trust administration work to do. That still, yes, might cause some stressors, right? So you want to pick those kids, those trustees who you think, okay, they're gonna be fine dealing with this. And I would even talk to your kids too. Like if you're trying to decide who you want as a trustee and you think they all would be equally good, maybe talk to them. Maybe you'll find one that says, no, I do not want to do this at all. Then you kind of know. If they all say they don't want to do it, I guess they just got to pick one. But it's not a bad idea to talk to them either, because there is some extra duties and responsibilities to it. Okay, I've already talked about this, so we're going to kind of skip over it, where you can have those professionals and the difference in kind of cost and the ones that I recommend. So how trusts work. So when the trust maker is alive and well, the trustees are usually going to be the trust maker and the spouse. So husband and wife are going to be the trustees of the trust when they're alive and well. And then sometimes it depends too. Sometimes when people set up trust with me, maybe their spouse is already gone, or their spouse is already mentally incapacitated, has dementia. Sometimes we're putting a child on with them right away too. But most of the time, it's husband and wife right away as trustees. But some of you might see you might be a child that's a trustee right now. And especially too, on mental incapacity, where it says on my incapacity, it's going to be spouse and one of my children. So you might be at that point too, where a spouse has already been deemed mentally incapacitated, and you as a child are already in as a co-trustee now with the other spouse. And then same with if one of the parents, one of the trust makers passes away, it's going to be spouse and one of the kids typically. And then we have those backups. That in case the other spouse, like on death, we typically require 2 trustees at a time. So then on first death, it's spouse and one of the children. And then on second death, that's where we like to have the backups listed of the other kids, because then the second successor trustee is going to jump up to be a co-trustee with that first child when the spouse passes away. So that's why we like to have those backups on there, so that it's already set up, already planned ahead of time, that on incapacity and death, here's who's going to be your trustees then, and who's going to be able to take over if they can't. So a trustee can resign. They can say, I don't want to do it, right? And they have to give notice to you if you're still alive, or to whoever the income beneficiaries of the trust are, and the next trustee. So they can just resign too voluntarily. And so that's why it's nice to have those other backups as well. Maybe, at the time when you set them up, it was good, but you on disability or death, it's like their personal life is just hectic, a mess, right? Maybe it's better for them just to step down and let the next child jump up. So that's all something that under life plan, while you're on mental incapacity, we will help you do those separate things, whether it's deeming you mentally incapacitated, or whether it's getting new trustees, helping one resign. We help you do that at no additional charge when you're in life plan. Now on death, to help you administer the trust, that first initial meeting with me is going to be covered under life plan. If that person who passed away is in life plan that year of death, that first initial meeting with me is no additional charge. But to administer after death, everything after that is a separate charge than your initial trust setup fee. So then it is charged hourly for any administration work we're doing. And then we send an invoice to the trustees. They pay it out of their parents' estate as a trust administration expense. Okay, so again, I get ahead of myself here on the slides. So we'll just touch base on some things I haven't talked about yet. So the disability trustees. So Article 4 is going to be the article that talks about mental incapacity. Majority of you are going to have that Article 4. And there's going to be a definition in there of when the trust makers are deemed mentally incapacitated. There's a specific definition, and then they're going to have that panel of people, whether it's doctor, spouse, kids, that all have to agree that they've lost their marbles to be removed as a trustee from their trust to kick in that disability trustee list. So these panels, when you see it, it's typically going to be doctor, spouse, and kids, right? Unless you have different dynamics going on, right? And the clients can pick whoever they want. If they have a ton of kids, sometimes maybe they're just picking a couple, because everyone has to agree that you've lost it to remove you. So, but we like to have the doctor, spouse for sure on there, and some of the kids, if not all of them, to deem you mentally incapacitated. And again, that's something our office helps with if we need to do it. And we have, other ways there's other ways set up in the trust to try to avoid this, to try to avoid having to go to a doctor to have them sign and get a certificate of disability signed by spouse, kids, and everybody. So that's why we have a trustee can voluntarily resign. likely the parent, the trust maker isn't going to want to voluntarily do that, but maybe if, if we can catch it and they're being cooperative, maybe they just remove themselves. And then like under your power of attorneys that you have, we have that certification of authorization of principal. It's the very last page of the power of attorney. And for most people, it's not signed. It doesn't get signed till you need it. So what that is helpful for is while you're still of sound mind, you can sign it over to your kid, where if your spouse isn't able to act under your power of attorney and your child is the next step, while you're still of sound mind, you can sign that, date it in front of a notary, and then it kicks it into your child. So we have some steps set up to where we can avoid this disability panel and try to get your child or whoever on as the next trustee. So on disability, the disability trustees, you're going to want to talk to contact me, the estate planning attorney. You're going to want to contact accountants, financial advisors to help you, because I just specialize in estate planning and elder law. I know some tax things, right? But we want to make sure that we're dealing with all the players involved with your assets. We want to work as a team while you're alive and well, on incapacity and death. So we want to have those people involved that are the tax specialists and can help us with those things. And then the disability trustees are going to serve until the trust maker recovers or dies. So sometimes, like we have built into the trust that maybe if you, like funny, I guess it's not funny, but we have built into your trust that if you go missing for more than 30 days, right, you're removed as a trustee, your incapacity trustees take over. Something that's not, pretty rare to happen. But I bring that up because something more realistic to happen could be if you have a stroke or some sort of medical condition where you are not mentally sound and they remove you as a trustee. Well, then you recover, you get your sound mind back, they can put you back on as a trustee too. So then you're back on when your disability trustees come off. Or on death, then in Article 3, we have, here are my trustees on death. So it might change. You've got to be careful to pay attention to that. But most of the time, clients are having the trustees on incapacity and death are the same list of people. But we just have to pay attention to that on death to be like, oh, this kid was a trustee on mental incapacity, but when we go and look at on death, it's a different one. It's unlikely, but we got to pay attention. They might be different. And then I left on here. So at the annual client meeting last year, I had gave a recommendation for the disability panel. So, like the doctor section of it. So if you have more than one doctor listed, if maybe you have two doctors, a doctor and a specialist, I told clients to maybe consider only changing that to one doctor, because it's hard enough to just get one doctor to want to sign that slip that you're mentally incapacitated. So last year is when I told clients that to look in your book and see and let us know if you want to change that. So I just wanted to put that plug out there again to look at that. If you haven't changed it yet, look at it and see if you might want to change it to just one doctor. Okay, so on disability, you're wanting to read and follow the trust instructions, because in Article 4, there's spots for specific instructions. We call it the rules on mental incapacity that the trust makers can list out. So there's always the boilerplate ones. Take care of them, what they need financially, take care of their spouse, take care of dependents. There might be some specific instructions for dependents, right? Like I built it in for clients where on incapacity, they say, okay, usually when a grandchild is born, I create a life insurance policy for them. So if I'm mentally incapacitated and can't do that, and there's grandchildren born, keep creating those policies or putting money into their college savings plans and things. So sometimes there might be some specifics there. Or if you have minor children, when you create your trust, we're saying, hey, take care of them until they're 25. Some specifics are going to be like specifics to your assets, right? So if you're a farming client, you're going to see built into Article 4 where it's telling the trustees, hey, here's who you have to rent to on my incapacity if I can't decide myself. Here's the rate you need to rent to them at. And maybe here's the second person you need to offer it to. And then usually it's going to say free use of machinery, tools, and equipment on mental incapacity, grain bins, storage sheds, those kind of things. So with family farms, it's important to put those specifics in there, especially if you have a farming heir that you want to make sure can keep renting, using the machinery that they're going to get from you on debt. Or if you don't have a farming heir, if you just had the same renter over the last so many years and they've been treating you well, they take good care of land, you want to make sure that your trustees offer that first right to rent to them. We want to build those things in there because then it makes it to where they have to do it. They have to follow those specific rules. So even if you're not a farmer, we're throwing specifics in there, right? If you have any other different type of assets that could trigger some specific rules on mental incapacity, we're wanting to put it in there. Like sometimes it's maybe you have a lake cabin and you want to lay out the use, or you have a child living with you and you want to make sure that the other trustees can't kick them out on your incapacity. Or if you have a business, we're wanting to lay out those rules on mental incapacity. Here's who's going to be in charge and manage your business if you don't already have a separate business entity document set up. Or like I built it in for clients who own storage sheds, apartments, that we're saying, okay, here's the kid who's been helping me with this business. I want them to manage it on my mental incapacity and things. So it could be some specific instructions that aren't just farming. On disability, they'll want to look at your trust asset list, inventory assets, and they need to maintain, preserve, and secure those assets. They're going to manage those assets and make investment decisions with key advisors. So I think is it Article 14 or 15 in the trust? It's the trustees' powers. So there's every power we can think of under the sun in there, right? That says, here's where the trustees, here's the powers they have. So they can do almost anything, buy, sell, convey, mortgage, borrow, like all that kind of stuff. And so they're typically, it's the normal maintenance and management of your assets. And then obviously we want to put any other specifics in there that you may need. So obviously they need to keep paying bills, provide for your care. They'll want to keep records and document transactions and business activities. So I think we learned from what I said earlier, if you have a child who's wanting to contest things and say, hey, trustee, I think there's funny business going on. You need to provide me copies of this stuff. So even if you think it's not going to happen, my kids get along, everything will be fine. As a trustee, you want to make sure you're having written documentation and you're keeping good bookkeeping and things of the things you do, because it's just going to be easier if you have to account to a beneficiary and show it to them of what you've been doing and what's been happening with your parents' money. You keep paying taxes, and if you're doing the quarterly estimates, right, you're going to make sure you're doing those. Count to the beneficiaries, and you want to communicate with the trust maker, advisors, and beneficiaries to make sure that you're still carrying out their wishes. If you're still able to talk to them and they're still able to be of sound mind to tell you, you always want to be in communication with them, because that has raised some issues too, where we have disability trustees and they're doing everything they're supposed to do, they're doing everything right, but they're not communicating back with mom and dad. So then mom and dad are getting mad and they're like, I don't know what they're doing with my money. I think they're doing this. And, and if there's dementia involved, they might be getting a little confused. So it's very important as a disability trustee or on death, if there's a spouse still alive, you want to communicate with them. You want to be transparent with them. You want to let them know what you're doing and things that are going on, so then they don't go to the worst case scenario and they're trying to call me and say they're stealing from me, or things like that. So the communication, you want to still communicate with them. Okay. On death, we talked about the trust become irrevocable, and we tell you contact our office right away on death. You don't necessarily have to get a meeting scheduled right away, but we would just like to know, so then we have a heads up. We like to send out sympathy cards and things. So you could just give us a quick courtesy call letting us know, hey, this person passed away. And then the person who's calling, it's either the other spouse or the kids, we're guiding them to say, okay, here's kind of the next steps. You'll want to do a meeting with Cassandra, but you don't have to do it right away. Get through the funeral, get through things. Usually we say about 30 days after death is a good timeline to meet with me, to go through the trust, to look at the to-dos on death. Obviously, if you have emergencies with paying bills or anything, call our office. We'll help you get any documentation you might need right away before that meeting. But usually it works out where you can just wait for that meeting, because as you've been hearing already this morning, it's a lot. It's overwhelming. And so it's easier to do this meeting with me after you've had some time to process and grieve and get through all the services and everything. You don't want to do anything with the assets, including transferring money, until you speak to me. But obviously, if you have access to be paying the bills and bills are due, keep paying those bills, pay the funeral bill, things like that. I already talked about it. Don't rush the family, allow grieving time, pay the funeral expenses, schedule the meeting for 30 days. So if you want to do something in the meantime of the meeting after death, you can be ordering death certificates. And, that's something the funeral home helps you with. The funeral home is going to help you get those death certificates ordered. And my kind of rule of thumb about how many death certificates to order is I say, okay, trustees, if you can, look at their asset list, or if you have a list of what assets they have, typically you're probably going to want a death certificate for each asset, right? Like if they have all their bank accounts at one bank, well, there's one death certificate. Everything at Edward Jones Investments, one death certificate. But obviously, if you have different banks, different advisors, you're going to want to get death certificates for each of those places. So that's kind of the rule of thumb that I say is for each asset, try to get a death certificate. I think the funeral home is usually going to probably help you order 15 to 20, I think is the general number that they start off with, and you can always get more. But so that's something you can get going right away. And the funeral home also helps you contact Social Security, because if they were getting Social Security benefits, you would want to get Social Security contacted right away, so then they know to stop the benefits. Because sometimes you might see, oh, we got a deposit. I called them the next day that they passed, and if they think that they shouldn't have deposited it, they have like so many hours, it's at like 72, they can just pull it right out of your bank account. So sometimes I tell trustees, be careful of that, because sometimes it might get deposited, but it wasn't rightfully to go to them based on their date of death. They might just pull it out of the account right away if they're within that hour limit. So you want to contact Social Security as soon as you can, but again, the funeral home helps you with that. Another thing that I tell people, something else that you could keep doing that the funeral home doesn't necessarily help you with, is contacting insurances to stop insurance premiums and things like that that they might be paying for that need to stop. So sometimes when you cancel those insurance, sometimes you're going to get a return of premium check in the mail, depending. And so sometimes there's issues with that, so you just want to talk to me, because depending how that check is issued, you might have issues because banks are getting really picky that the check needs to be written to the exact name that the bank account is in. So just call us, let us know, we help you work through that and make a plan to get that check deposited. You want to start gathering statements, you want to find the trust book. And so I tell clients, you always want to let your trustees, your kids know where you keep your book. And you don't have to keep it in a safety deposit box or in a safe at your house. Because remember, we've scanned in your documents, we have a backup. Copies are just as good as the originals. So, you don't necessarily have to have it locked up. You just need to have it in a safe place where all your other important documents in your office or things are, and make sure your trustees know where to locate it. Or if, some people still, they really want it in a safe safety deposit box, then you just need to make sure that maybe you have a separate writing somewhere hidden that says, okay, here's the code to the safe. Here's making sure they have access on the safety deposit box. And usually if they're like your power of attorney and things, they're going to have access to the safety deposit box, but that's while you're alive. On death, if the bank accounts and things are in the trust, and the safety deposit box is going to be considered that personal property in the trust, so then the trustee should still have access to that. But yeah, if you're wanting to lock it up and put it somewhere, make sure that they're going to have access to it and know where it's at. I already talked about Social Security. You gather life insurance policies. You're going to want to be letting them know so they can start that claim with the death benefit. You're going to have to get them death certificates and things, and then they'll issue checks, or they'll get it to the beneficiary that it has on the policy. So if we have a beneficiary to the trust, then usually you can coordinate with the life insurance on your own, and you can maybe even get that going before our meeting. And so you just give them a copy of the death certificate, and if it's beneficiary to the trust, they likely might want a certificate of trust and tax ID number. Because on death, these trusts become irrevocable. They have to get a separate tax ID number now, and they can't use the trust maker's social security number. So when you're alive and well, your trusts are going to use your social security number. They don't need a separate tax return, separate tax ID. But on death, they need that separate tax ID. So if it's beneficiary to the trust, that's something you might have to, those are the typical to-dos we help you with, is that certificate of trust that says, here are the trustees on death. So then the company knows who they can talk to and release information or have access to that account. And then we'll get you that tax ID number too. So oftentimes you can get the process going, call the life insurance. You can probably get them a death certificate, and then they're likely going to send you a form to fill out that says, hey, here's what we need now. And then you can bring that to the meeting then if you have it. And then I say, oh, we help you fill this out. We get these things for you, and we'll help you facilitate that. Okay, so the first meeting, what you can expect. So the first and foremost thing when we start the meeting, I ask how everyone's doing. Is there any questions? Is there any emergencies or things we need to address right away? Like, do we need a tax ID number before you can get access to a bank account and that certificate of trust? And oftentimes what we're trying to do is during that administration meeting, usually the trustees are there, all the trustees. So then we're going to have Allison create that certificate of trust and that tax ID number during that meeting. So then we can sign that certificate of trust by the current acting trustees because it needs to be signed by a notary. So we try to, if we can, we try to get it done during that first meeting so then you can walk away with the certificate of trust and tax ID after that meeting. But sometimes depending on if the trustees can or can't make it, we might have to help you facilitate getting it to the other trustees to sign. So obviously our greatest concern is for the surviving spouse and how they're doing financially. That's why we want to know, is there access to these accounts? Any issues paying bills? Because if there is, we're going to want to get you access to that right away to keep paying those bills. The surviving spouse, we talked about this, can serve as a trustee on death for the deceased spouse trust and likely going to be a co-trustee with one of the kids. The second meeting, what you can expect. So it kind of depends on the family and things, whether we have a second in-person, like final administration meeting on death. But usually that's going to be the meeting where we are signing deeds, signing documents to transfer their assets from the living trust to the family trust on first death. So it kind of depends, right? If it works out for the trustees to come in person again for that final signing, then you can just get it signed and notarized by us right there, and then we send it off to those companies for you to transfer it from the living trust to the family trust. We send the deeds off for you for recording. Or if it's second death, then we're signing at the final administration meeting. We're signing, usually it's deed work and things. We're signing documents to get assets transferred over to the kids. We're signing documents to establish their trusts. So it sometimes, yeah, it might be easier to do it in person, but again, it depends on the family, what they have going on, where the trustees are. A lot of times we're facilitating the signing when we're ready for the distribution side of it. A lot of times we're sending things by mail or whatever, email, working with you and maybe your trustees who don't live close to get things signed. So we talk to you about that. We work with you and see, how do we want to do this? Do we want to schedule a final administration meeting in person, or are we just going to kind of circulate signatures? And obviously, if anything needs to get mailed, we want you to sign it and return promptly. You know, we're trying to do things as quickly as we can for administrations, but sometimes, you know, we have to wait to mail things off and get signed and get it sent back and things. And some companies, you know, aren't always working with us as good or getting back to us right away. So sometimes it takes time. And so if we're doing anything in through the mail, please try to sign it promptly and get it back to us either by mail or email, however we direct you to do that. We talked about tax ID numbers. So on death, a lot of times we're likely having to get a tax ID number for the living trust when first spouse passes, because we're needing, that's your administrative trust on death. Even though it's your living trust, it's still the administrative trust where we have to get a tax ID number to get access to even distribute the assets out of the living trust to the family trust. So it might be that by the time we're ready to transfer to the family trust, then we have to get a different tax ID number for that family trust as well. Question?
That tax ID number, does that pertain if you have a will?
The tax ID number, does that pertain if you have a will? So if you don't have a trust and on death, you might need, so then you might have to get a tax ID number for your estate rather than a tax ID number for the trust. You're still getting a tax ID number for your estate that's keeping track of income and things coming in after your death and to that tax number. So that's something we can help with. Sometimes some trustees will do it on their own if they're familiar with it. You can go online on the IRS website and do it pretty quickly. There's some questions though that typically you're probably not going to know and that how to do, but we talk to you at that first meeting. You know, here's the list of things that the family should do. Here's the list of things we can do. And we talk about, okay, if you want to try to save some money and do things yourself, then we'll move sometimes some to-dos from our list to the family list. Okay, so we talked about the second meeting and beyond, what you can expect. So there's going to be new funding, right? We're going to be, on first step, we're transferring assets from the living trust to the family trust. If we fill that bucket with $3 million or whatever the estate tax exemption is, then we're filling the rest of it into the marital trust bucket. And then the surviving spouse still has their living trust. So then on second death, we're doing this funding and distribution and transferring assets from the family trust and maybe the marital trust as well to the kids, and then from the surviving spouse's living trust to the kids. So when the second spouse passes, we're not creating any separate family trust. We are just using their living trust as that administrative trust to pay expenses, finalize things, and then we're distributing to the kids or to the beneficiaries from that living trust. And then the first deceased spouse's family trust usually. But we might be dealing with a family and a marital. So then on death, one of the big to-dos for the family in the first meeting is I say, okay, here is the most recent asset list that we have on file for your parents, the trust makers. Here is kind of a starting point for you now that you would need to go through to see, do these assets still exist? Did they get new assets that they now have on death that they didn't update us to get on their asset list? And then we want the family to get us data death values for every asset that that person had on death that was in their name or in their trust. Because we want to do that because that's how we're trying to see, well, what was their total estate size on death? Are they above or below the 3 million? Do I need to guide the trustees that, oh, they're above the 3 million? So that means the trustees would have to file an estate death tax return within 9 months of passing. So that's one of the big deadlines you're working with on an administration, is if there's an estate death tax return due. Otherwise, the trust doesn't really specify a certain month or year deadline to administer the trust. It just says as soon as practicable, reasonable, so yeah, really that only deadline is that if there's an estate tax return. And then getting fair market value of real estate, you'll want to get appraisals, and so you want to get that going right away, especially if you have to do an estate tax return, because that might take a couple months for them to do and get the report back. So those are some things you want to get going on right away. You're going to need to prepare and file their personal tax returns, right? Whether it's joint or single, that final personal tax return in the year they passed away. But then too, after death, any income coming in, everything's in their trust on death, hopefully, then any income coming in is coming into that trust with that trust tax ID. And then that's going to trigger any income coming into the trust is going to trigger a trust tax return. So again, I go through all of this at that first administration meeting, and I'm writing it down for your spouse, your kids, your trustees of here are the to-dos, and guide them on possible tax returns and things that they have to do. And then something too that you have to pay attention to is an estate tax return. If you do owe taxes, that fee is also due within that 9 months when your tax return is due. The estate taxes are going to be due. So when you're working with your accountant, so you always want to, and I tell the spouse and the trustees this at the first meeting, is I say, okay, if we think there's an estate tax return due here, you need to talk to your accountant or your parents' accountant, because not all accountants will do estate death tax returns. So I don't do them, and so you want to talk to see if that accountant does. If not, I have suggestions and referrals I can give to the family of CPAs, accountants that will do estate tax returns. So not all of them do it, so you want to figure out if they do right away. So if not, you can find one. Or if they do it, you're giving them a heads up too, because their clock has started. And because these tax returns are not as easy as your income tax returns. They're very more detailed. You have to provide copies of everything, appraisals, death certificate, trusts, all the things, statements for every asset. So it takes them a little longer to get it. Oftentimes your accountant might file an extension, depending what time, how their schedule is looking, maybe someone passes away, but it's March, April, and they don't have a lot of time to get it going. They might just say, okay, we're going to file an extension. So work with the accountant on that. And hopefully they're guiding you that if any estate taxes due, if you're filing an extension, it's usually still due at that first 9 months. And if you don't pay it, then there's fines and penalties and things. So you want to make sure that we're working with the accountants on that, with the state tax, that we're getting it paid on time. And then on death, it triggers that step up in basis. So, like for example, I'll use, let's just say personal residence, or actually no, let's use farmland, because farmland, it might likely be that your parent their basis in this farmland is very low. So, let's say, so their basis is whatever they bought it for, this land, or whatever they got it for. So there's still some people out here that might have a basis in farmland of a couple hundred an acre. So then letting that real estate transfer on death is huge, because then on death, it triggers that step up in basis. So then the land goes to your kids with a new basis of whatever fair market value was on your debt. $12,000 an acre, on average, whatever it may be. So that's huge, because then if they were to resell it after they inherit it, they're hopefully likely not going to have any capital gains tax. So you have to be careful with that with gifting during your lifetime. You're also gifting your basis. So that's something you have to pay attention to with gifting. So you gift this farmland to your son while you're alive. Well, he also has a basis of $200 an acre. So if he sells it, he's got crazy capital gains. So, and there's ways around it with these irrevocable trusts, protect from the nursing home and things, but those are just some things to keep in mind. That all assets on death is what triggers it, whether it's, even if it's in your trust or not. Death is what triggers that step up in basis. And then obviously the trustees are going to provide care as directed in the trust. Care for spouse, children, dependents. They're going to follow those specific rules on death. Because on death, we're going to probably have specific rules for farmland. Hey, on death, you still have to rent to this person at this rate. Or if you want to sell your share, you have to offer it to purchase to this person, maybe at a discount on a contract for deed to make sure they can afford it, especially the farmland, if you want to keep that farmland in the family. So we're always paying attention. It's usually like Article 6 or 10, or we might have some specific things, specific distributions or rights and restrictions that we have to follow on death. Okay, we're going to quickly review the trust book here. So if everyone can get their trust book out in front of them, that big red book. And sometimes if clients have irrevocable trust with us also, it's going to be a green book. Or if they have LLCs with us, it's a blue book. But your revocable living trust that has like your power of attorney in it, your healthcare directive, all of those estate planning documents, that's going to be in your big red book. Okay, so when you open it, your parents, the clients might have some other important documents in there, because we say, hey, if you have important documents that relates to your estate planning and you want to keep it all organized in the book, you can put them in the book somewhere. So they may have some things in there, but typically at the beginning, you're going to have some introduction pages and cover pages to the trust. And then everything's tabbed out, right, to where you can quick flip to what document you may need. So in this book, you're going to find the revocable living trusts, the pour-over wills, certificate of trusts, the healthcare documents, the power of attorney, your personal property memorandum, and things in there. So first is with the trust. I've kind of, as we went on, I have pointed out important articles in the trust that the trustee is mainly going to have to reference. But like, I'll just go through some really quick. Like Article 1 is going to tell you like who the trustees of the trust are right now. And then Article 2 is the family information. When we're talking about our spouse and our kids and our assets are going to our descendants, we're referring to those people in that family information. So if we needed to write somebody out, it's going to be in that family information in Article 2. Or if we needed to write somebody in, right? If someone isn't a biological kid, grandkid, not adopted, we need to specifically say, hey, this person's going to be counted as part of my biological descendants. So then Article 3 is where you're going to find the trustees and the rules for the trustees. You're going to find who the trustees are on incapacity and death, and those rules like that a trustee can resign, that we want 2 trustees on death, things. And then Article 4, again, is another important one. how the trust is handled on mental incapacity. So that's where you're going to find the disability panel, who all has to agree to remove them as a trustee. And that's where you're going to find any specific instructions that you might have to make sure you're following as a disability trustee. So a lot of times it's going to say like farm provisions in there, or house provisions, or business provisions, or whatever that specific asset is, we'll kind of label it. So hopefully it sticks out. So as a disability trustee, you want to make sure you're looking through Article 4 closely, because there might be some specific instructions in there. Article 5 is how the trust is handled on death. So this is the article that I really go through in my first initial meeting on death with the trustees, because this is where I'm going through all those things. Hey, it's irrevocable. You need a tax ID number. You got to pay all bills. You got to get data death values. You know, that's how we go through that. And I create the list of to-dos for the family, and then to-dos that we help with. Article 6 is how your personal property is handled. So obviously it references that personal property memorandum in the back of your book, that tab. So personal property, your trustees have to distribute your personal property if you have any specifics there on that personal property memorandum. If there's nothing on there, then everything just goes into the pot, where we look at what does your Article 7 or your Article 10 say about how it gets distributed, and maybe it just goes into the pot equally to everybody. But if there's specifics, they have to distribute those specifics back there, and then the rest kind of goes into the pot equally, probably. So that's something we're going through too on death. We're going through Article 3 to figure out who the trustees are now. We're going to Article 5. We're looking at Article 6 in the personal property memorandum. So I can say, hey, trustees, here's specifics that you have to do. Oftentimes people don't fill it out. It's one of those things that doesn't seem like a priority, kind of a tedious thing to do. But I recommend you to fill them out. Usually the personal property is the cause of the family fights. And especially if you have all your assets going equally to your kids, there might be something sentimental to you that you want specifically to go to your daughter, or to specifically go to your son. Or maybe you have things that you want specifically to go to your grandkids right away, right? Because typically your assets on death are going to go to your kids. And then on their death, then it goes to grandkids. So any kind of sentimental things, you want to specifically write that down. And, you want to be careful on relying on, oh, my kids know, or they know what I want. I've told them, here's where I want this stuff to be split up. Well, we're human. We forget. Things get busy, so you just want to write it down so they can reference it. And it does hold them liable, right, to distribute it out too. Oftentimes a lot of people are writing, like, example, my grandma had a ton of little bells. And so, like, she would had a paper taped to them somewhere of the granddaughter's name, of who gets it. Or like in the personal property memorandum, she said each grandkid gets 8 bells, or granddaughter, excuse me. So, you can do things like that, but you also have to be careful if that tag falls off, or, things like that. So this personal property memorandum is there for you to have all that written down. It's in one spot, hopefully not going anywhere. You want to leave it there so it's there on death for the trustees to find. And it's a working copy. You can go back to it as time goes on and add things, take things off. You'll just want to date and sign each time you add things. And you want to put a good enough description on there so they know what it is. You don't want to do like ring 1, ring 2, ring 3, right? Put a good enough description that helps your trustees figure out what it is, and then next to it they're putting who they want it to go to. And then there's a spot for an asterisk. If it's a married couple, trustees, you'll need to pay attention because it'll give you guidance on, Do you distribute this piece of personal property on first death, even if spouse still survives, or do you wait till they're both gone? So we always look at that in the first meeting. I help guide you with that. Sometimes they don't have that one filled out, and that's the one that's legally binding, that references your trust and things. So if there's nothing on there, but maybe they have a separate writing that they just wrote down on a piece of paper on their own, that's not technically legally binding, but I tell the trustees, okay, well, hey, if this is the only list you've found, I recommend following that as a guideline. Or we've got to look at, are there multiple writings? Which one's the most recent? Maybe we have stuff in the trust book that's legally binding, and we have one that's written up that's not, so we got to pay attention to those things. 7, 8, 9 is typically that estate tax planning where we're creating the family and marital trust, and it's going to lay out the rules for the family and the marital trust. And then 10, for single people, Article 7, that's where it's going to say, okay, when we're both gone on my death, this is where my assets are going. And you should see that if there's any specifics, we're going to have paragraphs right away with all the specifics before we just say everything else goes equally or however, So that's where we want to lay out specifics with rent, first rights to purchase, machinery, if there's specific assets going to specific people, we want to lay that out in Article 7 or Article 10. And then anything else that's not specific, it's going to say, distribute the rest to my descendants per service, right, is what it might say. Well, that means to my children, to my people listed in Article 2 in equal shares. And then it's going to, Article 10 or 7, it's going to create those trusts for those kids. Or it's going to say you need to distribute to them in trust, and it's going to lay out the rules for the kids' trust. That they have full access to the income and principal or not. And it's going to lay out where it goes on their debt. And then the rest of the articles is just paragraphs, lawyer language, tax language, things just we need in there to tell us, well, if this comes up, what do we do? And all the trustees' powers are in there, and like Article 15, I think. So a lot of that is just non-specific paragraphs to your planning. So if any of you have any questions about those, give us a call, or if we need to do a more in-depth review meeting of the trust going through, we certainly can. Next, I believe, is the pour-over wills. So it's kind of confusing, right? We say, don't do wills, do trusts. Well, we still give our clients a will with their trust, but it's our backup. It's there for anything that is not in their trust on debt. So like those vehicles that aren't worth much. So then we say, okay, here's the people in charge of my will. They're called personal representatives. They're usually going to be the same people as the trustees of your trust. Here's who's in charge of it. Then it says, hey, get a hold of this asset and pour it over to my trust. Get it to my trust, then it can go down as my trust says. Or if it's just vehicles and things that isn't worth much, we're not going to transfer it to the trust, but it's going to get them ability and control over it to sell that vehicle or whatever. So that's what the will is. The will is not going to say any specific stuff besides who they want to charge. So it's just our backup. And then next is the power of attorney. So that document we need for while you're alive, but mentally incapacitated. So who's in charge of your finances while you're alive, but you can't make those decisions for yourself. So an easy way to think about it, trustees and clients, is whatever is in your trust when you're alive, it's your trustees who are in control of it. If you're mentally incapacitated, but your assets are in your trust, your disability trustees are in control. But if there's assets that are not in your trust while you're alive but mentally incapacitated, that's where your power of attorney, this financial power of attorney comes in. And usually I recommend clients to have the same list of people because the trust, power of attorney, they're documents of who's in charge of your finances and your assets. So usually it makes sense to have the same people in charge of both. Power of attorney is not going to have a lot of other specifics in it. Your specifics on mental incapacity are going to be in Article 4 of the trust that you need to follow. But these power of attorneys are huge, right? I think they're like 26, 27 pages. They're very powerful power of attorneys. So we say, again, it gives your attorney, in fact, is who they're called, who's in charge of your power of attorney. It gives them power over anything they may come across. Whether it's assets you might have later that you don't have now, or it's assets you're never going to have. We want to make sure that no matter what comes up, they have the power and control of it, so we don't have to worry about, oh, we got to go to court now, or how do we got to do all this other stuff to get control of it. So they're very thick, and yes, you want to get a copy of that whole thing to your bank. You don't necessarily have to get it to the bank now if your child is not in effect under your power of attorney, right? So like typically on incapacity, and if your child then becomes in control of your power of attorney, then you need to get a copy of that to the bank. So yes, they like that old copy, but call us. We can always email it. We have a scanned in version of it that we can email it, we can fax it, we can mail it for you, right? Because I realize, some people might not be able to make a copy of that whole thing at home. So let us know how we can help. Sometimes you can just bring that power of attorney to the bank though, and they can just copy it for you, scan it in. So you always want to get your original back though. Never let them keep your original. You always want to keep your originals in the book. Make copies for who needs copies of each document. Then certificate of trust. So certificate of trust is kind of a short version of their revocable living trust. It's only gonna give the information that banks or life insurance agents, those kind of things, and investments, the information that they need to know about the trust. So it's just gonna have a quick breakdown. Here are the trustees. It's revocable. It goes by their social security number. Here's how we want assets titled. So typically, right away when we are funding your current assets to your trust, and we're saying, hey, bank, please change this payable on death to this trust, we're sending a copy of that signed certificate of trust with you. So that's what we have to provide to places so they know who can do what, who are the trustees, and what can they do. And so obviously, as trustees change, we need to update this. So on mental incapacity and death, we will get you new certificates of trust as the trustees change, and then you would need to update those with those companies so they know that now who can we deal with and talk to and let access these accounts on incapacity and death. Then there's a trust assets tab. This is where usually I recommend clients to put their asset list in, or any other documents that relate to their assets. That recorded deeds showing that their property has been recorded to the trust. So you might find those there. So that's something that, again, like my clients, they get that sent out to them every year that they can update, or you call in and update as you want throughout the year. And then this is the asset list that we print out for the final, or for the administration meeting, where I say, okay, trustees, here is the most recent asset list we have on file for your parents, the trust makers. Here's your starting point to see what they have, figure out the date of death values for these accounts, see if these assets are still there, what ones are we missing. So use that asset list on death. Next, you'll find healthcare documents. So in the healthcare documents, the first one is going to be a HIPAA document. Who has access to their healthcare information? Who can the doctors talk to? So that's going to be the first one. And then I should have said as we've been going along, these trust portfolios are set up to where if it's a married couple, everything's in just one book for the both of them. But we have husband's documents first, and then you might see a purple cardstock page or a gold cardstock page that's going to separate husband and wife. So like under your trust tab, you'll see husband's trust first, cardstock document, then wife's trust. So it's going to be set up like that for each document under each tab. Okay, so healthcare, you have the HIPAA, and then right after the HIPAA is the healthcare directive. This is where their healthcare power of attorney or their living will is, traditionally what it was called. So this is what's going to tell you, here's who's in charge of their healthcare decisions. Now you got to pay attention to the list here because the list might change, right? Because who they had in charge of their finances under the trust and the power of attorney, there might be a separate person though who wasn't good at finances. That's the nurse in the family that they want in charge first of the healthcare directive. So it'll lay out who can make those decisions and the backups, typically with the other kids. And then in the healthcare directives too, I don't remember the exact numbers, but in the healthcare directive, you're going to find specific instructions. If you're the healthcare agent, they're going to tell you, the trust maker or the maker of this healthcare directive, they're going to tell you, hey, here's what you do for my end of life. They're going to tell you whether or not you have to pull the plug or keep you alive for so long. They're going to tell you in there whether you can donate their organs for transplant only or for any purpose. And it's also going to tell you in there if they want to be cremated or traditionally buried. And then oftentimes, clients are going to have in their books maybe a separate burial plot information that they've already bought. Or if they've created irrevocable funeral policies, you might find in their book a separate irrevocable funeral policy contract that lays out everything that shows what's been paid and all the decision making for that cremation or that traditional burial. So usually I tell clients, stick that in the memorial instruction tab. So we'll get to that in a second here. But those are kind of the specific things that you'll find in the healthcare directive. And then, okay, so next is that memorial instructions. So this is just a little extra thing we provide in our estate planning portfolios. It's not a legally binding document. This is another document they can write on. So your personal property memorandum and your memorial instructions should be the only documents you're writing on. You want to keep all these other documents nice and clean, so that way when you're making copies, you're giving people clean copies. Also, if you want to make any changes to your documents, you have to do it in a separate writing, signed and notarized by you. So I typically recommend put stickies in your trust, in your power of attorney or your other documents, your healthcare directive. Put stickies where you have questions, post-it notes, where you have questions or you want to make changes. So then it's easy if you're talking to me on the phone, you're quickly flip into those to say, hey, I want to change this. Oh, here's my question about this. Or if you come in person to me, bring the book, I can easily flip to your stickies and go from there. So you want to keep the other documents nice and clean, don't write on them. But the memorial instructions, personal property memorandum, you can write on. In the memorial instructions, it's not legally binding, right? They can write on it if they want to. I say it provides a great gift for your surviving spouse, to your kids, to help them take the time to grieve rather than panicking and stressing over, oh my gosh, who's going to be the clergy? What are going to be the scriptures? What's the music? All of that kind of thing. So you can lay this all out for them ahead of time. Some people even pre-write their obituaries, right? That you can do that and really make it stress-free for them. So I recommend filling these out too. Obviously, it's not required. And then I talked about those irrevocable funeral policies. So I like to push for those because then it's paid for, it's done, all those decisions are also laid out. And then they wouldn't have to fill out the memorial instructions in the book there. And then if they need to get on medical assistance while they're alive, that irrevocable funeral policy is exempt. They wouldn't have to spend that down or get that out of their name to get on medical assistance. So that's kind of nice because if you were relying on other investments or life insurance to pay for your funeral, well, what if you go into the nursing home and all that gets spent down? All your investment accounts get spent down. You have to spend down cash value in life insurance, and maybe that death benefit goes away. So that's where these irrevocable policies come in. I try to say pre-funded because maybe a downside to them is if maybe you've dealt with it, if you have had parents that created them, but they created them a long time ago, and they didn't have a good inflation policy built in, sometimes you might have to pay in some more on death depending what they paid in before. And if it didn't quite go with inflation and meet where the prices are these days. So I do caution you on that. And when you're creating these policies, you can go and create them at the funeral home, and essentially they create a life insurance policy for you. So it has to be irrevocable and beneficiary to a funeral home. So they help you get that all set up. So make sure to talk to them about, hey, do you have like inflation clauses built in? Because usually some of them can build while you have the money in there, and figure out, how that works. So those are good things to do that on death can have it all planned out, paid, but also helps if they go into the nursing home. We've already talked about the personal property memorandum in good detail. And then that assignment of personal property that we talked about way at the beginning of this meeting is going to be behind their personal property memorandum. And then there's a spot for other documents where if they want to keep any of their other estate planning documents in there all in one book organized, there's a spot to put that. Or like I'll tell clients, hey, if you have a burial plot set up or you have an irrevocable funeral policy set up, you could put those under the memorial instruction tab. Or anything specific like that that might fit under a specific tab, you can do that. Or maybe you just have it all in the back. Okay, so with trust settlement, so on death, when the trust makers are the client, and then on death, the trustees are our clients that we're representing as trustees of this trust. So if there's any issues with beneficiaries and things, I can't represent the beneficiaries, right? I'm representing the trustees of the trust. So beneficiaries have issues, need legal advice as far as their beneficiary interest and their beneficiary rights. They would have to hire a separate attorney to help advise them with that. Trust makers, the clients in life plan upon death, they have that signed contract with us that allows that free initial consultation for that first meeting. So I've already talked about that. But the successor trustees, they have no obligation to hire our firm. Yes, we help with the trust administration on death, and we recommend it since we're the ones that created the plan and are up to speed on it. But they can go hire whoever they want to. And sometimes maybe it makes sense if your trustees live far away, and it's easier for them to just hire an attorney close to where they live. But, these days with technology, things can be done remotely. So we can still work with trustees out of state. We're video chatting, phone calls, emailing, mailing things. It can still be done. And a lot of times they try to schedule a meeting when they're back, maybe for the funeral services or as they're coming back to tend to assets and things. We can still try to do in-person meetings. Okay, so these are just some cautions as a trustee. You never want to commingle trust funds with personal funds. You don't want to roll over IRAs, retirement accounts without verification of tax and legal assistance. Be careful about using retirement plans for final expenses. It might be taxed higher, taking it out to pay for an expense rather than letting it go to the beneficiaries. Use prudence and reasonable care or skill in investing. Seek professional assistance and skills and experience are lacking. You are responsible to the trustees, so you must always act you're responsible to the beneficiaries. You must always act in the best interest of the beneficiaries. You want to communicate with the beneficiaries, advisors, co-trustees, and respect any deadlines for action. So leave yourself, the attorneys, the accountants time to meet deadlines, right? Like especially with that estate tax return. If you know you have to do one, and I'm going to advise you typically like, hey, it looks like at that first meeting, oh, hey, it looks like one's probably going to be due. Contact your accountant. So you have that 9 months to do that estate tax return. So you want to respect those guidelines, get an accountant involved right away. So next steps for you as you leave this meeting and on is invite your trustees over for dinner, or you're going to have everyone over at the holidays. I know it's probably not something that fun to do, but I recommend showing them when they're over, hey, here's where our book is, here's where to find it, here's where to find our codes and our passwords to everything. Go through the book with them of any specifics. Okay, so in closing, being selected to serve as a trustee, it's an important service that you can do for your loved ones. Your job involves responsibility and accountability to the beneficiaries. So a lot of times, again, to try to avoid the sibling fights or someone trying to say, oh, there's funny business going on, I'm going to hire an attorney. I think a lot of that can be avoided if the trustees are just communicating with all of the beneficiaries, keeping them in the loop of what's going on. Then again, they don't just go to the worst and think you're stealing or things and want to request all these statements to prove you're not. So I think if you keep them in the loop, keep communicated, it's probably going to save you some extra work in the end. And then with our legal assistance, professional accounting, and key advisor assistance, you will do just fine. I know this seems like a lot, but you have a lot of people behind you to help. You have our office, you have the accountants. We're here to help guide you and translate that trust for you. Really quick before we go, I just wanted to do kind of a recap. I talked about some of this already, but a recap of like law changes and things that I talked about at the annual client meeting if you weren't able to go. So really quick an update to the firm is we have a new employee. So Abby left us last January, and then as the client service coordinator, and then we had Jackie Darst in there for a little bit. She's from Stillwater, so it ended up happening that she moved back to Stillwater. So now we have Stephanie Sandhurst in as our client service coordinator. She's from Fulda, so I'm hoping she is here to stay, and she does an amazing job. So some of you might already have met her, talked to her, but she's going to be the one answering the phones, taking the walk-ins and stuff, and really helping you with things you need. And then we still have Allison. Allison is in the back as our administration coordinator, funding coordinator. So changes in laws. So the federal state tax exemption with the big beautiful bill. The federal state tax exemption is going to increase. Right now it's 13.99 million. It's going to increase next year to 15 million, and it's going to be that permanently unless further laws change it. So there's no plan for it to sunset after 5 years, like we thought before. Like we thought that maybe it was going to sunset to around 6 to 7 million beginning next year. But that's not going to happen, thank goodness. It's 15 million, and that's going to be permanent unless laws change it. So then that's also going to be your lifetime gifting exemption. So that means you won't have to pay taxes on gifts over the $19,000 unless you use up all of your $15 million. So that's helpful still for nursing home planning or estate tax planning if we're trying to gift most of this farmland or something like that with high value out of your name to protect it for the nursing home, this high lifetime gifting exception really helps us to do that without paying extra gift taxes. But remember, when you gift more than $19,000 per person per year, you have to file a gift tax return. But you shouldn't have to pay taxes. The annual gift exemption staying at $19,000 this year. We talked about that already. Minnesota estate tax exemption is at $3 million, and it's going to stay at $3 million again next year. With the possible for the farm and small business exemption of $2 million. So there is a possibility that on death, you could qualify for an extra $2 million if you own farmland and you have that homestead classification, having a relative farming it, things like that. So I also help guide the clients at that first initial meeting of, oh, you are over the $3 million, but you're likely going to qualify for the $5 million to help with the state tax. So it's not automatic like the $3 million is. You actually have to have your accountant file that form with the estate tax return on death to see if you qualify for it. So that's something that's possible. There are not a lot of new changes to the law that really affects things or big changes that you have to make to your trust. The couple of things that I talked about were changes to the rule of how long trust can last in Minnesota. So, question.
You mentioned just a moment ago with $2 million of homestead exemption. Is that something we have to file ahead of time?
So the $2 million homestead exemption, is that something you have to file ahead of time? So yes, so every year, right, you're filing documents with the assessor's office to keep your homestead exemption, right? If you can have one. And so you want to make sure you're doing that because on death, you want that homestead exemption, is it that like class 2A or something classification that you need on death. So if you weren't keeping up with it while you were alive or the year you passed away, you didn't turn in the documentation in time to the county and you didn't get it, that's going to affect getting that extra $2 million added to your estate. So while you're alive, you need to make sure that you're turning in your documentation to keep your homestead credit. But it's mainly going to be something that is applied for on death to see if you qualify. But if you can get a homestead credit, make sure you have that applied on your year of death. Is that how you're still looking for this?
Well, my property tax comes back and it all says non-homestead.
Okay. So if your property tax comes back and it says non-homestead, maybe look, because sometimes it might say a special like ag homestead or something on there too. So we might need to just talk over the phone about that, or calling the assessor's office too helps. But yeah, that's something that you have to have for that extra $2 million on debt. Okay, so the rule for how long trust can last, so it's called the rule of perpetuities. So like South Dakota and other states, they say trust can last however long. There's no deadline to when they need to terminate. So those help with what's called dynasty trusts, where you can keep assets in the trust for as long as you want to keep things protected, keep things in the family. So Minnesota, it was the current law, or the law before it changed in August, is that it was like 100 years it would last. Well, now trust created after August 1st, 2025, they can last up to 500 years after death. So it's not as good as South Dakota, like a lot of things. It's still going to last now for, as long as we really wouldn't need it to keep things in the trust and keep it protected. So I told clients at the annual client meeting, a lot of you probably have in your trust that language, like 100 years plus 21. If you want to change that so that it can last for 500 years, we would need to amend it. So just let us know. But really, what's in there now is probably still gonna be as long as you ever need it to. So, but just let us know if you wanna update that. And then there was a new rule with, now, this is more relevant today because it's a new rule for trustees to know. So on death, Minnesota law gives like a 3-year limitation for contesting a trust after death. So that's in the Minnesota statutes. But there's now a new Minnesota law that says that trustees, though, they could shorten that notice to 120 days after death to contest the trust, rather than the 3 years. But there's specific notice that they have to give to the beneficiaries that says specific things. So that is something new that, you don't necessarily have to put in your trust. I had recommended clients that you could put it in there. Then it's just in the rules that it's written down for the trustees. But that's something in the administration meetings that I'm going to be telling the trustees now too. Hey, if you want to shorten this time frame that they can contest, here's what we got to do, and we will help you send that appropriate notice out. That's just going to help with that uncertainty, right? Not worrying about, oh my gosh, there's 3 years for random lawsuits to show up, things like that. It's going to help the trustees with that uncertainty to know, hey, we can get things distributed out and get this done and closed up. And then we talked about the family legacy letter was the big educational piece at the annual client meeting. So that's just an extra thing we provided to the clients where it provides the human piece, the whys to your estate planning. It's not going to provide anything that's legally binding, your trust and what happens and who's in charge on death is what goes. But this family legacy letter that we provided is where you can write down for your kids, your trustees, hey, here are our values we hold important. Here's the whys. Here's why we chose who we did to be in charge. Here's, why we chose which assets to go where. You can really lay out all of that. We gave them a worksheet in your packet of information, lifetime clients. So then you can use that and take it to put into this family legacy letter and create a letter to your kids, or you can just leave it on the worksheet for them to find. So those were the big updates from annual client meeting. Okay. I feel like this probably went longer than I anticipated. I get talking and things and I think of more things that I think, oh, while the trustees and the kids are here, this is going to be helpful for them to know. So I appreciate your patience and hanging in here with me. Do you have any final questions you want to ask in front of everybody? Otherwise, you can come up and ask me more personally afterwards too. Okay, I'm not seeing any questions. So reminder before you leave, fill out that full sheet, that client suggestion form, and then just leave it at the back table where you picked up your packets on your way out. So I thank you all for coming. And like I said, I'm glad it was warm enough so we still got a good turnout. And I hope you all can travel safely back to where you need to go before the storm starts. So thank you all and happy holidays. Merry Christmas. Thank you.